Morning, Karen. How are you?
I am just so happy to be here. I'm good. How are you?
You've just come out of a hotspot in North Melbourne, haven't you? This is your first day out of the house.
Yeah. Yep. It's been a really I'm not overstating it. It's been a really stressful week. It's in my part of town.
Well, it's good to be here, isn't it? We're talking about some books we read before, and I just finished reading Hishman Matar's The Return, and one of his lines was, "Turns out need and uncertainty can be an excellent teacher." And I reckon that's where we've been, hasn't it?
Yeah.
Fourth lockdown. Think of what we do. You're just talking about seeing our staff during lockdown. Just describe what that's like.
Oh yeah, no, you could. It's funny being when we're in lockdown. Lockdown 4.0 is you can always tell when we're in lockdown stage because of what people are wearing. It's like instantaneously everyone's in their hoodies and their worst home clothes, right? Versus, because now we're all working in part blended remote, that on any other day when you're working remotely, you're still kind of, quite presentable. But in lockdown, you have full permission and it's safe for you to just wear whatever you want to wear. So I just think it's pretty funny.
The other thing I thought was funny yesterday, and I put a post on LinkedIn, is we said to staff, and we've got 25 people across Zoom, so what are you going to do when lockdown lifts? And to a person, they said, they talked about a person they loved, whether it was their brother, their sister, their partner, whatever. We're going to go to a local restaurant to support them and be out with someone we love. And they booked the next 5 days.
Well, they love a lot of people. So, yeah.
But it's a very, very reassuring thing when you talk about people's values and the way Victorians have responded to lockdown. Yeah. That's a really heartening part of who we've been.
Yeah.
Okay, well, let's get into what we're going to talk about today. We're going to start off with some more stuff on the gig economy. You'll recall a couple of weeks ago, we put out an article and we discussed the Deliveroo case, which talked about whether someone's an employee or a contractor who is delivery rider under in the gig economy. And you'll recall when we spoke about this, I said, we're really stuck with our politicians. We've got the Liberal Party who's completely disinterested in the whole process and wants the old common law world and says they're contractors. We've got the Labor Party who's also disinterested and wants to make them employees. And you've got courts saying they're really a different group of people. They're actually quite different. There is a third part. And the courts are gradually trying to craft that remedy. But what we're seeing in the absence of federal intervention is state-based legislators starting to create rules. And the New South Wales government have produced some regulations under their WHS, which talks about these people, because they had 4 deaths in a very short period of time, delivery riders must wear PPE, must be identifiable as who they are, must be trained correctly. So they're utilising the health and safety legislation to say, I don't care whether they're an employee or a contractor, they must be safe. Now, that's 1 out of 8 jurisdictions in Australia in safety, but that's going to flow across very, very quickly. And Victoria is not part of the WHS, but they had an inquiry only recently which reported 6 months ago. But once again, they said there's something about the risk for these people. They're lowly paid, they do high-risk functions, they don't have a set status. So I think, Karen, we're in for a lot of legislative change because we're just too slow to move on who these people are.
Yeah, it definitely, and it's just a really complicated space as well. So it is confusing in terms of understanding who's meant to be doing what and how much of it you own by way of responsibility. But we're going to see and hear a lot more through these type of announcements and cases as well. So we'll keep reporting on it.
Yeah, and look, the thing we're seeing throughout the world is the gig economy is not just food. We're seeing it starting to chew into traditional roles that were previously employment-based roles. And that's really where the major change is going to come. As I've said to you, Singapore's employment structure now has around about 30% gig workers. In other parts of Asia, it's up to 40%. So it's an issue which we're currently addressing, and part of that is to set very clear processes while there is this dichotomy between employee and contractor to make sure they're contractors. But we now know that safety law is looking at them and saying, I don't care who they are, you make them safe.
Yeah, absolutely.
All right, well, look, that's the first thing. We'll keep you up to date as we go with that. Really interesting case of Safe Work New South Wales and Southern Meats came through. This is really a case which I guess we warn our clients on time and time again, that is after a serious incident occurs, what you do in the immediate aftermath to remedy that problem is evidence of what is reasonably practicable for a court. So the court can say, so you could do this afterwards, why didn't you do it before? The important part about this case is that they were served with an improvement notice by the regulator. Now, just to be really clear, when the regulator issues improvement notices, they don't look at reasonably practical. They look at trying to prevent it from ever occurring again. So it's common that the test, if you looked at it, you go, well, that's more than what is reasonably practical.
So they overprescribe.
They overprescribe. But what you want to do is you want to get back into production. You want to get it fixed. Your moral situation says, I never want this to happen again. Mm-hmm. And so you comply. But
employers are also freaking out at the same time, thinking like they just want to make it go away. So they do what they think they're meant to be doing quickly, not really thinking through what does this mean.
And then they've created something they actually can't live by. So I guess my point about this case is the case is not on that issue, but it's on that issue for me. Never assume when you get an improvement notice that you have to comply with it. Test it. Get some advice, get an expert in, challenge the regulator. They'll change them sometimes. If not, there's an internal review process.
Yeah.
But I think, what were you saying over breakfast this morning? Was your example about kids?
Yeah, when I was reading about this, I couldn't help, sorry guys, I keep on going back to my children because that's just where my head's at. But it's almost like having an incident occurring and then you're telling a child not to do something again, and they promise and they say they promise the world, but they're not conditioned yet to be able to change fundamentally that quickly. I mean, you can make changes. You got to moderate those expectations and make sure that there's some room for them to fail and learn and grow. So I couldn't help but just...
No, it is that. And I guess the issue for us is that this case says unquestionably future conduct is evidence of what is reasonably practical. And the difficulty, once you've complied with a notice, which is prima facie proof of breach as a matter of law, you've exposed your officers, because then the officers are deemed to have that knowledge, even though you can't do it. You can do it for the 5 seconds that the regulator comes through and inspects it, but you can't maintain it. And the last thing is, when you have an incident, yes, you have to show what you're doing in respect of what caused that incident. But when a regulator comes through, they will issue improvement notices on anything that's wrong in that area, none of which was caused of the incident. So remember, part of our strategy is when a problem arises, to make sure we get our expert out first, who locks and tags out anything so you can get it back in commission immediately. You can make it safe to reasonably practical, not to a higher level. There's a strategy that sits behind it. Not what the case was about, but it's a good point in the sheet. All right, next case is Liberty Finance and Djugovic. And this is a case about a restraint for a very senior person in the finance business. He went from one very large finance company to another. He had a restraint which was objectively reasonable. Can I explain what reasonable is? Because that's the test of what restraints are. They must be reasonable for the nature of the interest that his business is protecting. As we were talking about hairdressers earlier, if the average time which a person goes to a hairdresser is 4 weeks, then a restraint for 6 weeks, which means it prevents you from taking someone out of their normal cycle, would be a reasonable time. But the other thing is you must protect something that's special within the business. And this is the real issue. In Djugovic's case, this person had an understanding of margins, clients, products. They'd acquired them. They weren't given a special document that said this is confidential, but they'd acquired this information just from having a leadership role. And the court said, an incredibly clever federal court judge said, look, this information must be protected. It's the very sort of information that the other new business desperately wants. It gives them a competitive edge. So you've got to take them out of that cycle until that information becomes redundant, or effectively redundant. But what happened in this case is a warning for all young players, I think, is Djugovic went off and saw his lawyers, and the lawyers thought, oh, there's that great case of Crow-Horwath and Luu, which says if we can find any repudiatory conduct from the past employer and we accept it, it kills the restraint. And what had happened in this case is he hadn't been paid some leave. And so they identified it as repudiation, accepted it and said, sorry, the restraint doesn't work. And the judge picked it and said, well, this is just a contrivance. You've already resigned. Don't bring this up. And I guess what my father's saying, which I quote too often, which is don't be too smart by half, is be careful, lawyers, advisors and people. Stay with what the real issue is, because once you burn a judge in a case, you really burn that judge because the lens changes. And I'm not saying they lack objectivity, but if you do something which is disingenuous, you lose trust very quickly in a court. And in a court, you've only got seconds of trust. So the moment you tear it up, you've gone. So look, that's what the case is about. Great case on restraints, Karen. And I think for us, it talks about who should you restrain and what you should restrain.
Yeah, absolutely. And I think the thing with restraints is that too often, again, they're templated. And it's a one size fits all, and it's not, because they need to be tailored to that particular individual based on what their role is. So example, Andrew, a principal lawyer for you, one of your, let's say for Kim, head of workplace, her restraint would and should be different to one of our associates or one of our junior lawyers. It's just the risk is different, the exposure, the information. You got to remember, what is the point? Why are you having a restraint in the first place? What are you actually trying to protect? And
that's where you go first, is what is it that you're trying to protect? And if you've got nothing to protect, don't try, because the court will look at you and go, that's just rubbish.
Yeah.
And the other part is, remember, when you're hiring someone as talent, every barrier you put to talent, you keep talent away. So if you're putting a restraint against somebody who's a senior associate, they're looking and say, well, why would I come to you? Because you're actually taking me out of the market if I don't get on with you. So that's one part of it. But I think the other part is, if you say something's confidential, then create a process that acknowledges that confidentiality. Partly because, as my oldest daughter would go, duh, it is confidential. So you actually should treat it that way. But secondly, if you end up in court, you can go, look, this isn't just something that Karen acquired. This is something which we mark confidential. There's only 2 or 3 people who know this. Who knows what makes Coca-Cola? Who knows what the spices are for KFC? There's a reason that is protected. Okay, same in your business. All right, now I'm going to move over now, Karen, to not Karen's corner, but to Karen's checklist.
Yes.
Go.
All right, sure. So I'm covering off workplace investigations today, and I've been doing an awful lot of them, and I do often get the question asked around, so how do you go about running investigations, particularly really complex ones? So, Sophie, we got a slide. Now, you will get this as well in email to you. So, look, what I did, and I thought might be helpful to some of you who are working in this space, conducting workplace investigations, is a little bit of a cheat sheet. And what I've got in here is, look, I've outlined things what my mindset's like, a couple of tips for you guys as well, in terms of to consider before and during your investigation. So I'll start off with talking about the mindset of an investigator. What I mean by that is, what is it that you're trying to do? Like, what should you always keep at front of mind in preparing and conducting an investigation? And I must say, it is the objective, certainly when I do it, is about establishing what happened versus what the story is, because there are a set of facts and there's a whole lot of different people involved, and different people will form their different narratives. Your job is to be able to pierce through that and establish exactly what those facts are, and be able to draw, in terms of a conclusion, in terms of, look, based on what you're hearing, this is what has most likely occurred. So that's what it's about. And also be aware of the potential risks that might be at play. So, for example, if it's a workplace-related, employment-related issue, there will be factors around workers' compensation potentially. There'll be safety factors. Like, just understand in terms of, before you walk in there, like what are the potential laws and rules that might be relevant. In terms of conducting an investigation, start with the end in mind. Again, remembering what's the problem that you are trying to solve. I'll talk about this later in some of the tips, but if it's about conducting an investigation to prove that, say, the employer, if you're just trying to predetermine a narrative or a story, that kind of defeats completely the point of why you're doing an investigation. Okay, so it's about understanding, again, what happened and exactly what is it that you want to understand in terms of what happened. Is it an incident? Is it a series of historical behaviour? Be clear on what that is. Understand the context. So what do you need to know about the organisation, the function, the team, the person, the people that you're interviewing as well? All that's going to help. Setting a clear structure. For me, ordinarily, the structure that I would adopt when conducting these investigations, I keep it really simple, because I think of the audience. Who is going to read this report? What is the issue? And there could be several. what are the rules that relate to that issue? What are the facts that we know based on interviewing people? And then from that, establish what is the finding. Okay, it's not your opinion. It's what, based on everything I've just outlined there, did it occur? So is the issue or the allegation substantiated? It's unsubstantiated. It's inconclusive. Now, I know that's very simple, but that's as simple as it should be, Andrew.
Yeah.
Demonstrate objectivity in your thinking and language. Really important. Language needs to be very neutral, because you don't want to say like, so-and-so always says or always thinks. It appears as though this person is always doing, like, that's really quite dangerous language to use.
Well, and it also breaches the rules around investigations, which are fact-based rather than impression.
Exactly. But it's when you're writing, if you're not thinking and keeping that at the front of your mind, it's really easy to just kind of,
If I can remember next week, and Soph, if you can remind me, I'll pull out half a dozen cases just to give you examples of HR people who've got this wrong and been identified and criticised in the Fair Work Commission for doing all the things that you were saying not to do. They did them. They started off with a preconceived narrative. They failed to put a structure in place. They then pursued self-interest or the interest of the organisation. So there's a lot of things that go wrong at the end of it, but the thing I want you to know for HR people who are doing this is you're burning your brand. Just remember your personal brand is on fire when you breach these rules.
Yeah, absolutely. And in terms of asking difficult questions as well, how do you actually do that when you're working with people, usually in a very difficult circumstance? Building that rapport, I mean, I know this sounds really straightforward, but being respectful and building that rapport early on, creating a safe environment for people to share information with you and for it to flow back and forth. I find I haven't found people to be generally evasive when I'm working with them, but if someone's having trouble answering a question or they're seemingly reluctant, I present the information a different way. So look, here is what this looks like. What are your thoughts on this, or how does it sound to you? And then they can respond to that rather than a yes or no. So again, that comes with experience.
And be careful. I think we're very careful when we work with you. We don't tell you the employer narrative. We just give you facts.
Yeah.
Be really careful that whoever is the person who is doing the investigation has not been told the narrative or the outcome you want. Don't do that, because it poisons the well. Even if the investigator is entirely objective, that conversation has poisoned the well. And from that moment on, the whole process is poisoned.
Absolutely. Other factors to consider in terms of before you start is who are you interviewing? Ordinarily, there will be, let's say, a person who's raised a grievance or a complaint. There will be certain witnesses. Think beyond that. Have a think. Are there other key stakeholders that would be relevant to this issue that you need to consider consider as part of the process as well? Timing. Try and keep them as close as you can to keep the momentum going. There's nothing worse than drawing things that can be done within a week out to 2, 3, 4 weeks. It just creates unnecessary anxiety for everyone. Location, Zoom, in-person, on-site, off-site, those kind of things are really important in terms of what's appropriate depending on who you're seeing. And also the frequency of interviews as well. If it's a complex matter and there's a lot to go through, don't try and make it all happen in one go. Try and split it up if you need to. And sometimes when it's multiple issues, break it up, so that you get
Don't be scared to speak to someone 2 or 3 times.
Absolutely, yeah. And the other bits just there, as I mentioned earlier, being respectful, courteous, don't prejudge, keep an open mind, don't withhold information. Okay, so there's stuff that you think, well, should I not give this to the investigator? If you want us to arrive at a finding that is factually based and the integrity is there, we need to know. And really important, Andrew, allow yourself time to think. And I found that increasingly over time that I really need to there's all this information, you need it to land, you need to analyse it and consider things, but you need time to do that. So
could I just, at the end of it, I want for the people who are engaging, Karen, to remember this. As lawyers, we actually give an oath about how we don't mislead courts. Okay, so that's an obligation we have on us. But remember, as an employer, your brand is honesty, and therefore trying to get a result by getting an investigator to find an outcome. You may get your outcome on the first whack. You may terminate the person on the basis, but you'll be back before the Fair Work Commission. You'll be paying money because you've taken risk. But what you're doing is burning brand. I don't think we've ever been disappointed in the work Karen does, because funnily enough, what we think is going to happen mostly happens, but we get so much information, privilege, that comes out of the top 3 legal professional privilege that tells us where the problems are, that there's this great opportunity of learning and development that comes from it. So trust good investigation. It actually has great results. Don't try and manipulate it.
Yeah. So hopefully that's helpful.
It was helpful to me. Now you can take that down, Saf, so we're back on. There's an article we've just put up from Matt Reitman, who works with us, on out-of-hours conduct, because we got quite a lot of feedback last week about, well, don't understand quite how this works. And in a very simple way, it works this way. There are 2 limbs for workers' compensation for incidents that occurs out of work. Those which are directly related or caused by work. Karen, we're going to go and have a drink after work. Okay? Caused by work. If Karen is injured during that period of time, it's not a question. It's during employment, so it's part of employment. But then there's ones which are, we're going away for a retreat the weekend, everyone gets drunk and falls over. Okay? And that's the second limb under workers' compensation. And also you find in negligence, where they talk about arising out of the course of employment. And that's what all the cases were about we talked about last week. Now, Matt's article goes into that in depth. What you've got to show is there is a deliberate nexus between the conduct that caused the injury and the employment. It's got to show that the work directed or wanted or induced the person to do it. So it's not enough they say come away for the weekend, but they didn't induce you to go and drink 8 bottles of Benine. Does that make sense?
Yeah.
That's when you went off on a frolic of your own. The problem is because workplace legislation is benevolent legislation designed to protect workers, is that employers are much more easily liable than workers are. So when it comes to terminating workers for misconduct that's out of hours, you go to a case called Rose and Telstra. And that has a very high test, much higher than this, that says you've got to show that the conduct of the employee was completely contrary to the nature of the employment they were in. Okay, so, and there's lots of cases around that. There's fighting cases, all sorts of things. But what you've got to show is the person can never come back to work. What they did prevents them from ever reasonably coming back to work. And Shockman's case last week was not about employment law. It was about workers' comp and negligence. It was more about negligence. But in that case, that was the case the guy urinated in the employee's mouth in a accommodation provided by the employer. The guy got drunk, drank this on an island resort, drank at the employer's drinking spot. Everything was controlled by work. They must have known those risks existed. And there's a case that's directly on point about that. So I just want you to understand policies and processes are so critical around both of these limbs in workers' compensation. What you do when you have authorised work occasions, what happens when you're directed to go on a work-related function. But also we must be very clear about what out-of-work behaviour is inimical to being at work, and be very clear what the business will do, and then not condone it. So if Karen, who's a boss, does it, you go, oh, it's okay. But if Andrew, who's not a boss, does it, and that's where the problem lies. Now, we've got to get in. We're running late because we've had Karen's checklist was fantastic today, and I just let it roll too long. So let's go on to the case study. So, well done. Gee, you're hot today, Sophie. I've got to tell you. No, that's it. So Henry was the foreman of a road crew at a road building company called Hard Road Proprietary Limited. Hard Road worked building remote roads and put their employees up at local pubs. Henry was a very exact man. He was a civil engineer who built perfect roads. However, he suffered with very bad asthma, which was made worse by anxiety. He had experienced 3 asthma attacks at work, 2 requiring an ambulance. There were 3 members from the same family working in Henry's crew. The eldest, Darren, hated Henry. Darren and his 2 brothers were often late to work, and when challenged by Henry, just laughed at him. Henry told his boss, Ben, who said, they are all we can get during this time of COVID, just be strong. Henry was not strong. There's a second slide here. It was Friday night at Lismore Hotel, and Darren, his brothers and some other patrons came up to Henry's room, threatening to lynch him. I think that's the name, lynch. I'm not sure that's how we'd spell it. They knocked loudly on his locked door and were shouting. They were very drunk. It was just meant to be a joke. Henry had an asthma attack and luckily called 000. He was saved by a paramedic. The incident happened at 1:30 a.m. on a Saturday morning. Work finished at Friday at 5 p.m. and was to recommence at 6 a.m. Monday. Henry's doctor says the incident, along with the prior condoned behaviour, meant he could never come back to work. Poll. So, there we go. Now, you'll have to expand that because maybe I've got it on my last few pages. We don't have to worry about that. Yes, we have.
You do.
Okay, this is a hard set of questions, so This doesn't seem too hard. Everyone's saying the right answer. So. How are we going with numbers there, Karen? I'm too blind to actually say.
Well, we're about 60% voted already.
So we'll give it another 10.
Yep. Okay, we get ready to close it off, guys. 3, 2, 1. Thank you very much.
Okay, let's bring up our results so we can see what we've got.
And we'll share the results. All right.
All right, you'll have to do. Very good.
Yeah.
Okay, so the first question is, was Henry's stress claim compensable? So let's do the legal tests first. So the first test is, did work cause it? No, work didn't cause it, so it doesn't fall under the first limb. Did it arise out of the course of employment? Well, let's do the hotel they were directed to stay at. They were staying all together at that hotel. They weren't able to come home. The employer was aware of Henry's problems with asthma. The employer was aware of conditions that created anxiety and were aware of that nexus between anxiety and the asthma. So it is borderline, and there's a case called Dring and Telstra, which we've talked about, that came out later last year. I think because Henry's done nothing to break that causative chain. So Henry didn't go out and swallow drugs or something that increased his anxiety. Henry was just doing his job being there. So I think it's definitely compensable. Yeah. Could Hard Road and Darren be in breach of safety legislation over their treatment of Henry? Karen and I talked about this earlier today. Safety legislation is benevolent legislation. So it puts its arms very, very wide, just like discrimination legislation. It finds workplaces where the other people don't. So I don't think there's a doubt that it's a workplace. Yeah. I think any judge who got hold of it would go, well, wait a second, you monitor the health obligations. You know this guy's got anxiety. You know that the people who cause him part of that anxiety working there. You know he's got asthma. And you fail to do anything in the monitoring of health and the providing a safe environment for him. I think the safety legislation would find them liable. And I think the judge would cruel, so I like using that word, but it would cruel the organisation for the manner in which they behaved. Could Darren's employment be terminated? Now, we've got some mixed messages on that, and I think that's a really interesting part about it, because we don't know completely what Darren's done, by the way. But I suspect the people who are going, I'm not sure, are talking about condonation. Yes. And I know I belt on about this a lot, but law of condonation says I can't punish that which I've committed. We know that Darren's done some shocking behaviour. We know that he's demonstrated he hates him. We know that he is dismissive of his authority. We don't know the level of that bad behaviour because the facts don't disclose it. So for the guys who voted in between, I get it. So if Darren had done something similar like this before and it had been condoned, then I think you'd have trouble terminating him. We don't know whether Darren's a ringleader in this. We just know he is a participant. But my feeling is if he came to see me, I'd terminate him, and I'll deal with it later, because he is incredibly destructive and dangerous. So this is not a legal question at this stage. This is a practical question. And that's commonly what comes to me, is people saying, we want to get rid of this guy, and because they've done these things. And I say, well, look what you've condoned. Look what you've let happen. Yeah, I can create an evidential structure that supports the termination. I can create a valid reason, but will it be harsh? Will it be harsh is the question. So, the first test with unfair dismissal is there a valid reason? Undoubtedly, there's a valid reason. You then go to the next 3 tests, which is it harsh, unjust, or unreasonable? Unreasonable, is it disproportionate? Unjust, is it not true? Last question, is it harsh? Well, if you condone it before, and I think given the nature of what occurred, given the near fatal consequences of it, the Fair Work Commission is a very human commission. And so is actually the Federal Magistrate, which is if there was some sort of adverse action constructed to get it there. They look at what nearly happened and they struggle to disassociate themselves from it. So I think the short answer is you'd be able to terminate Darren's employment, but you would be settling in a conciliation. Yeah. So look, that's it for this week. Thank you very much. Great to see Karen out and breathing the air and enjoying. We've had coffee together today, and that's been really nice. And lovely to see all of you out of lockdown and everyone else in Australia who's not in lockdown.
Yeah.
Well done. See you soon.
See you soon. Have a great long weekend.
Bye-bye.
Bye.